student body. Opponents contended that reserving set-aside spots was itself discriminatory, irrespective of the institution's motives. The fractured decision. The Supreme Court's decision in Bakke was famously split, with multiple opinions preventing the formation of a single majority rationale. Justice Lewis Powell authored the controlling opinion, holding that quotas or set-aside seats were unconstitutional, but that race could still be considered as one factor in a holistic admissions process. Powell's opinion rested on two key points. First, the specific 16-seat reservation system at UC Davis went too far, effectively excluding otherwise qualified non-minority students solely because of their race. Second, universities could lawfully consider race if it served a compelling interest in diversity, a concept Powell borrowed from First Amendment academic freedom jurisprudence. Marshall's separate opinion. Justice Marshall authored a separate opinion in Bakke, concurring in part and dissenting in part. He agreed that diversity was a valid goal, but he disagreed with striking down UC Davis's specific admissions plan. In Marshall's view, a strict prohibition on any form of racial preference ignored the hard realities of inequality, effectively barring institutions from taking robust steps to ameliorate discrimination's effects. He insisted that the Constitution should permit race-based measures where they are narrowly tailored to broaden opportunities for underrepresented minorities. Crucially, Marshall's opinion drew on history to argue that colorblindness was not a constitutional imperative. It is a moral, political, and constitutional tragedy that the court adopts a stance of racial neutrality, which ignores the reality of the situation. Racial neutrality is an outright impossibility. The position of the Negro today in America is the tragic but inevitable consequence of centuries of unequal treatment. He recounted how African Americans had been systematically denied educational opportunities and how contemporary disparities were the legacy of that institutionalized oppression. For Marshall, the very text of the 14th Amendment, born out of Reconstruction, demanded that government actively dismantle racist structures, not simply stand aside under the guise of neutrality. Significance of the case. Bakke left colleges and universities with a complicated directive. They could consider race, but only under certain conditions, and outright quotas were impermissible. While some observers read the decision as a partial win for the concept of affirmative action, Marshall felt that the court had missed an opportunity to endorse a more forceful remedy for entrenched inequalities. Nevertheless, Bakke became the cornerstone for future affirmative action jurisprudence, with Marshall's perspective continuing to inform debates over how far the Constitution permits or requires race-conscious efforts to achieve true equality. Beyond Bakke, other affirmative action rulings. Fulilove versus Klutznick, 1980. Just 2 years after Bakke, the court tackled an affirmative action program in the area of federal contracting. Fulilove versus Klutznick concerned a congressional act requiring that at least 10% of federal funds for public works be allocated to minority-owned businesses. The court upheld the program, reasoning that Congress has broad power under the enforcement provisions of the 14th Amendment to remediate the effects of past discrimination. Marshall joined the majority, reiterating that the Constitution does not inhibit the federal government from enacting remedial measures for historically disadvantaged communities. For him, Fulilove validated the notion that while states or localities might face stricter scrutiny when using racial classifications, the federal government could exercise its authority to redress pervasive discrimination through carefully designed legislation. Wygant versus Jackson Board of Education, 1986. In Wygant, the court struck down a school board's policy that protected minority teachers from layoffs based on the board's interest in maintaining racial diversity among the faculty. A 5-4 majority concluded that the policy violated the Equal Protection Clause because it imposed disproportionate burdens on non-minority teachers without sufficient remedial justification. Justice Marshall dissented vigorously. He argued that the policy served a compelling goal, ensuring a diverse set of role models for students. He also pointed out that traditional seniority-based layoffs would likely perpetuate the underrepresentation of minority teachers, given the enduring vestiges of discrimination in hiring. For Marshall, the court's decision demonstrated a persistent reluctance to confront the structural realities that perpetuated racial disparities. instead adhering to a narrow reading of equal protection that often advantaged more privileged groups. City of Richmond versus J.A. Croce & Co., 1989. Another critical case arrived in City of Richmond versus J.A. Croce & Co., which involved a municipal set-aside program reserving 30% of city construction contracts for minority-owned businesses. The court invalidated the program, applying what it called strict scrutiny to any state or local use of racial classifications. According to the majority, Richmond had not provided adequate evidence of specific, identified discrimination that would justify the sweeping quota. Once again, Marshall dissented, lamenting that the majority's approach demanded an unrealistic standard of proof, effectively stymieing state and local governments from remedying discrimination unless they could document each instance of its existence. He reiterated that racial disparities do not arise in a vacuum. They often reflect complex histories of bias. In his view, requiring a perfect record of discrimination before allowing remedial measures misunderstood the nature of systemic racism and perpetuated an illusion that colorblindness alone could achieve equality. Marshall's core themes in affirmative action. A pragmatic reading of the 14th Amendment. Marshall interpreted the Equal Protection Clause in light of its Reconstruction-era origins. Far from mandating colorblindness, he believed it was meant to undo the social and economic legacies of slavery and Jim Crow, which demanded active government intervention, recognition of systemic inequities. Marshall consistently warned that seemingly neutral policies often masked racially disparate impacts. He pointed out that individuals from minority backgrounds frequently began at a disadvantage because of inherited social and economic disparities. Affirmative action was one way to level the playing field, giving disadvantaged groups the foothold they had been historically denied. Narrow tailoring versus broad goals. While fully supportive of race-conscious programs, Marshall also recognized that they must be sensibly tailored to withstand constitutional scrutiny. He endorsed the idea that government entities needed clear objectives, be it diversity or remedying past discrimination and a demonstrable rationale. However, he strongly opposed the court's tendency to demand extremely specific proof of recent, intentional discrimination, arguing that such requirements ignore historical realities and make effective remedial action impossible. Fairness to all versus reverse discrimination. Critics of affirmative action often invoked the specter of reverse discrimination, suggesting that measures to aid minorities came at an unjust cost to white individuals. Marshall rejected this framing, insisting that the real inequity lay in centuries of discrimination that left minorities with fewer opportunities. By focusing on the disadvantages historically inflicted on minority communities, he reframed affirmative action as a partial corrective to an entrenched imbalance, not an unfair handout. The moral dimension. For Marshall, the push for race-conscious remedies was never merely about numbers or statistics. It was also about dignity and moral justice. Laws and policies that ignore structural disadvantages perpetuate a status quo steeped in centuries of injustice. Affirmative action, in his view, advanced the Constitution's highest aspiration, that all citizens have an equitable chance to flourish. Ongoing resonance of Marshall's affirmative action jurisprudence. Although Marshall retired from the court in 1991, his influence continues to shape debates over affirmative action, both within the Supreme Court and in the broader national conversation. The framework outlined in Bakke persisted into later cases such as Grutter versus Bollinger, 2003, and Fisher versus University of Texas, 2013-2016, where the court reiterated that diversity in higher education can constitute a compelling interest, but that admissions programs must be carefully tailored to avoid undue burdens on non-minority applicants. Marshall's dissents in Croce, Wygant, and other cases also anticipate modern critiques about requiring exacting proof of identified discrimination before allowing race-conscious remedies. Advocates for robust affirmative action policies today often cite his arguments on systemic racism, pointing out that contemporary inequalities are the cumulative result of historical prejudices, and thus cannot be cured by colorblindness alone. Moreover, the philosophical underpinnings of Marshall's stance, his insistence that law must account for structural inequities, not just overt discrimination, resonate in contemporary discussions of equity in housing, criminal justice reform, and voting rights. While the Supreme Court's composition and legal standards for affirmative action have evolved, the moral and historical arguments Marshall advanced remain central to any serious discourse on how to achieve true equal protection for all Americans. Conclusion. Thurgood Marshall's jurisprudence on affirmative action provides a revealing window into his broader constitutional philosophy. Through cases like Bakke, Fulilove, Wygant, and Crossan, he repeatedly underscored that equal protection is not a static, one-size-fits-all doctrine. Rather, it is an evolving mandate that must respond to real-world inequalities and discriminatory legacies. Marshall believed it was insufficient to declare formal equality while ignoring the deep-rooted disadvantages that continue to affect minority communities. For him, affirmative action was not about displacing one group in favor of another. It was about ensuring that the promise of the 14th Amendment, shaped by the ashes of slavery and intended to guarantee full citizenship for freed African Americans, had genuine force in modern society. If the law did not allow for race-conscious remedies, the entrenched effects of racism would remain unchallenged and intact. Consequently, Marshall insisted that restricting government entities to a purely color-blind approach often perpetuated the very inequities the 14th Amendment was designed to eradicate. While Marshall did not always persuade a majority of his colleagues, his separate opinions and dissents have served as intellectual touchstones. They remind us that the Constitution's commitment to equality requires more than negative liberty, freedom from state-imposed discrimination. It may also demand affirmative steps to lift historically burdened populations. Long after Marshall's departure from the bench, his unwavering championship of affirmative action underscores a continuing tension in American constitutional law: how to balance a desire for colorblind principles with the urgent need to remedy the present-day consequences of past injustices. In the broader arc of Thurgood Marshall's legacy, his stance on affirmative action and equal protection extends and reframes the civil rights triumphs of his earlier career. Where Brown and the Civil Rights Acts dismantled explicit racial barriers, affirmative action sought to address the hidden residue of that discrimination in education and the workforce. Through meticulously reasoned opinions, Marshall argued that the Constitution, not just as text but as a living instrument, permits and indeed encourages such remedies. Ultimately, his perspective endures as a powerful testament to the ideal that equal protection, if it is to be truly equal, must sometimes be actively pursued rather than passively observed. About the author. Johan Drolshagen is a seasoned technology expert with deep expertise in cloud architecture, software engineering, system administration, DevOps practices, and content management systems. His professional experience spans diverse roles, including technical leadership, strategic consulting, and innovative digital solutions development. In addition to his technical pursuits, Drolshagen is an accomplished author and researcher, specializing in the intersection of technology, law, and governance. His extensive body of work includes books, scholarly articles, and policy analyses, exploring how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain interact with legislative frameworks and public policy. Through his writings, Drolshagen seeks to bridge the divide between technological innovation and legal governance, creating valuable resources for policymakers, legal professionals, technologists, and academics. His multidisciplinary approach supports the development of informed, adaptable legal systems capable of responding effectively to rapid technological evolution, thereby fostering equitable and sustainable policies in an increasingly digitized global society.